fees incident to such filing, registration, recording, and all expenses incident to the preparation, execution, and acknowledgement of the documents described in subparagraph 2, and all federal or state fees and other similar fees, duties, impositions, assessments, and charges arising out of or in connection with the execution and delivery of the 2013 note and the collateral documents and the documents described in subparagraph 2. D. Financial information. The borrower will cause proper and adequate books of record and account to be kept showing complete and correct entries of all receipts, disbursements, and other transactions in such reasonable detail as may be determined by the borrower in accordance with generally accepted governmental accounting practice and principles. It will cause such books to be maintained on the basis of the same fiscal year as that authorized by the borrower. Are utilized by the borrower. The borrower shall also have prepared and supplied to the bank within 270 days of the close of every fiscal year an audit report prepared by an independent certified public accountant in accordance with generally accepted governmental accounting principles and practice with respect to the financial statements and records of the borrower. The audit report shall include an analysis of the borrower's compliance with the provisions of this loan agreement. Further, the borrower, within 60 days of the close of every fiscal year, shall also have prepared and supplied to the bank a financial statement by an independent certified public account with respect to the Crow Tribal Trust Fund, showing at a minimum the principal balance of said fund, the assigned interest income, the outstanding principal balance of all bonds, notes, or other indebtedness secured by the assigned interest income, and the annual debt service relating to the secured obligations. Article 3 reserved. Article 4, the 2013 loan. Section 4.1, the 2013 loan, disbursement of the 2013 loan. The bank hereby agrees to lend to the borrower at such time as the requirements of this section 4.1 are met, an amount in the aggregate not to exceed $10 million for the loan purposes of borrower. The 2013 loan shall be disbursed as provided in this section 4.1. The bank shall disperse the 2013 loan directly to the borrower and to no other party. A. In consideration of the issuance of the 2013 note by the borrower, the bank shall disperse the total 2013 loan amount in a single advance not to exceed $10 million upon receipt of the following documents. 1. An opinion of counsel that the signatories to this loan agreement, the 2013 note, and the collateral documents are the proper parties to execute said document, that the signatories are vested with authority to enter into agreements, execute a limited waiver of the borrower's sovereign immunity from suit, to consent to jurisdiction of disputes under said documents in the United States District Court subject to the provisions of section 11.7 below, and that the signatories can and do bind the Crow Tribe to the terms of said documents. And 2, the 2013 note fully executed and authenticated. 3, the loan agreement fully executed and authenticated. 4, the assignment fully executed and authenticated. 5, any other collateral documents reasonably required by the bank as a condition to their approval of the 2013 loan. 6, payment or provision for payment of the origination fee. 7, the executed OST acknowledgement of the 2013 loan in a form acceptable to the bank. And 8, such other certificates, documents, and other information as the bank may require. B, in connection with the funding and disbursement of the 2013 loan to borrower, the bank shall not be obligated to see to the application of the proceeds of the 2013 loan. Section 4.2, commencement of loan term. The borrower's obligations under this loan agreement and the collateral documents shall commence on the date hereof unless otherwise provided in this loan agreement. Section 4.3, termination of loan term. The borrower's obligations under this loan agreement and the collateral documents shall terminate upon payment in full of all amounts due under the 2013 note and the loan agreement, provided, however, that the covenants and obligations provided in Article 6 and Section 11.8 shall survive the termination of this loan agreement. Section 4.4, assignment. Concurrently with the execution and delivery of this loan agreement, the borrower will execute and deliver the assignment pursuant to which the borrower will assign to the bank the assigned interest income payments to assure the full and prompt payment of principal of and interest on the 2013 note, provided that the foregoing is not intended to restrict the source or method of such payments by borrower to sums received with respect to such Crow Tribal Trust payments, and the obligations in this loan agreement, the 2013 note, or the assignment shall be general obligations of the borrower. Prior assignment of the assigned interest income payments. Borrower warrants that the Crow Finance Authority has previously secured the 1. the Series 1997 bonds by the pledge and assignment agreement. 2, the 2000 note by the supplemental pledge and assignment agreement. And 3, the 2007 note by the second supplemental pledge and assignment agreement, each of which pledged and assigned all of the right, title, and interest of the borrower to certain portions of the assigned interest income payments and granted a lien thereon to secure repayment of the Series 1997 notes, the 2000 note, and the 2007 note. Borrower further warrants that it is not granted, bargained, sold, assigned, pledged, transferred, conveyed, warranted, mortgaged, hypothecated, or otherwise encumbered the assigned interest income payments to secure any other indebtedness. Article 5, repayment of the 2013 loan. Section 5.1, repayment of the 2013 loan. The borrower shall repay the amounts lent pursuant to Section 4.1 hereof, plus interest on the outstanding principal balance from time to time at the applicable rate, subject to annual adjustment on January 25th of each year. The 2013 loan will be amortized over a period of approximately 15 years. The 2013 loan repayment shall be made in accordance with the following. A, 2013 loan repayments. The 2013 loan shall be paid, 1, in consecutive semi-annual installments of principal and interest at the applicable rate on January 25 and July 25 of each year, commencing on January 25, 2014, and continuing through January 25, 2028, and 2, a final payment of all outstanding interest, principal, and other sums due on the 2013 note or under this loan agreement shall be made on or before July 25th, 2028, all the foregoing being subject to the rights of prepayment set forth below. B, application of payments. All payments of principal and interest shall be applied first to interest due on the 2013 loan and then to reduce the principal amount thereof. If any installment of principal or interest is not paid when due, each and every such delinquent obligation shall bear interest to the extent permitted by law at the applicable rate from the due date of such installment until payment thereof. The borrower shall pay all 2013 loan repayments in lawful money of the United States of America to the bank. Interest shall be calculated on the basis of a year of 365 days, 366 days during leap years. Interest shall accrue from the date the advance is made. Any payment of principal or interest under this Section 5.1 shall also be credited against the same payment obligation under the 2013 note. C, statement of amount due. At least 30 days before the due date of a semi-annual principal and interest payment under Section 5.1A1 above, or the due date of the final payment under Section 5.1A2 above, the bank shall deliver to the borrower a written statement specifying the amount of such semi-annual payment or final payment as the case may be. Notwithstanding the foregoing, the failure of the bank to deliver said written statement shall in no way or manner, 1, relieve the borrower of its obligations to make such payment, 2, relieve or excuse borrower from the performance of its duties, obligations, or covenants under this loan agreement, the 2013 note, or the collateral documents, or 3, impair or diminish the bank's rights and privileges under this loan agreement, the 2013 note, and the collateral documents. But the due date of semi-annual payment or the final payment, as the case may be, shall be extended to the date which is 30 days after delivery to the borrower of said written statement. Section 5.2, additional payments. The borrower shall also pay within 30 days after receipt of a bill therefore from any legally available funds therefore, including proceeds of the 2013 loan if the borrower so chooses, all reasonable expenses of the bank in connection with the 2013 loan, the collateral document, and the 2013 note, including but not limited to 1, the cost of reproducing this loan agreement, the collateral documents, and the 2013 note. 2, the fees and disbursements of counsel utilized by the bank in connection with the 2013 loan, this loan agreement, the collateral documents, and the 2013 note, and in accordance with the provisions thereof and the enforcement thereof. To the extent, 3, to the extent lawfully applicable, all taxes and other governmental charges in connection with the execution and delivery of the collateral documents or the 2013 note, whether or not the 2013 note is then outstanding, including all recording and filing fees relating to the collateral documents in this loan agreement, and in accordance with the provisions thereof, all expenses including attorney's fees relating to any amendments, waivers, consents, or collections, or enforcement proceedings pursuant to the provisions hereof or thereof. Section 5.3, prepayments. Borrower may prepay the 2013 loan and the 2013 note without penalty or premium in whole or in part at the option of the borrower on any one or more dates. In the event of any partial prepayment, the amount thereof shall be applied first to interest due on the 2013 loan and the 2013 note to be prepaid, and then to reduce the principal amount thereof. All prepayments shall be applied on the principal in the inverse order of maturity, and shall not relieve borrower from paying the next succeeding installment or installments of principal and interest due hereunder and under the 2013 note. Section 5.4, obligations of borrower unconditional. The obligations of the borrower to make the payments required by this loan agreement and the 2013 note, and to perform its other agreements contained in this loan agreement, the 2013 note, and the collateral documents, shall be absolute and unconditional except as otherwise provided herein or in such documents. The borrower, A, shall not suspend or discontinue any payments provided for in this loan agreement and the 2013 note. B, shall perform all its other obligations in this loan agreement, the 2013 note, and the collateral documents. And C, shall not terminate this loan agreement, the 2013 note, or the collateral documents because of commercial frustration of purpose or any dispute with the bank unrelated to the loan agreement, 2013 note, or collateral documents, or any change in the laws of the United States or of the state or any political subdivision of either. Article 6, indemnification of the bank. The borrower shall indemnify and save harmless the bank and its officers, employees, and agents, each an indemnified party or collectively the indemnified parties, against and from any and all claims, damages, demands, expenses, liabilities, and losses of every kind asserted by or on behalf of any person arising out of, resulting from, or connected with the condition, use, possession, conduct, management, planning, design, acquisition, construction, installation, or financing of the borrower's properties or operation of its affairs. The borrower shall also indemnify and save harmless the indemnified parties against and from all costs, reasonable counsel fees, expenses, and liabilities incurred in any action or proceeding brought by reason of any such claim or demand. If any proceeding is brought against an indemnified party by reason of any such claim or demand, the borrower shall, upon notice from the indemnified party, defend such proceeding on behalf of the indemnified party. Notwithstanding the foregoing, the borrower shall not be obligated to defend or to indemnify or defend an indemnified party or any of its officers, employees, or agents, or hold any of them harmless against or from or in respect of any claim, damage, demand, expense, liability, or loss arising from the intentional or willful misconduct, negligence, gross negligence, or breach of the loan agreement, 2013 note, or a collateral document of the indemnified parties. Article 7, assignment. Assignment by borrower. The borrower may not assign its rights and obligations under this loan agreement or the 2013 note without the consent of the bank. Section 7.2, assignment by bank. Subject to applicable federal and state securities laws, the bank reserves the right to sell to other banks or financial institutions participations in the 2013 loan and the 2013 note, and to disclose to the participants such information regarding the borrower's affairs as the bank may possess. Article 8, the 2013 note authorization. The borrower is authorized to issue, execute, and deliver its notes and other obligations to obtain funds for the loan purposes. Section 8.2, outstanding debt. Except for the obligations described in Section 4.5 above, no bonds, notes, or similar indebtedness are outstanding which are secured in whole or in part by the assigned interest income payments. Section 8.3, issuance and delivery of the 2013 note. The borrower has investigated or caused to be investigated the facts necessary and hereby finds, determines, and declares it to be necessary and desirable for the borrower to execute and deliver the 2013 note to evidence the 2013 loan. Section 8.4, terms. The 2013 note shall be in the maximum principal amount of $10 million, shall be issued as a single advance term note, shall be dated as of the date of delivery to the bank, and shall bear interest at the rate charged by the bank on the 2013 loan. The principal of and interest on the 2013 note shall be payable on the same date and the same amounts as principal and interest of the 2013 loan repayments are payable. Advances of principal of the 2013 note shall be deemed made when advances of the 2013 loan are made under Section 4.1. Borrower may prepay the 2013 note in whole or in part only upon the terms and conditions under which it can repay the 2013 loan under Section 5.3. The 2013 loan and the 2013 note contemplate a single advance not to exceed the aggregate principal amount of $10 million in accordance with Section 4.1 above, and the 2013 note does not represent a revolving credit of any nature or form whatsoever. The borrower expressly recognizes that payment of the amounts due the 2013 note and the 2013 loan shall not obligate the bank to advance nor entitle the borrower to borrow or receive any additional advances, monies, or sums under the terms of this loan agreement or the 2013 note. Section 8.5, execution and delivery. The 2013 note shall be executed on behalf of the borrower by the manual signature of the chairman of the executive branch of the tribe. Such signature may be affixed at or prior to the date of delivery of the 2013 note. In the event any of the officers who shall have signed the 2013 note shall cease to be officers of the borrower before the 2013 note is issued or delivered, their signatures shall remain binding upon the borrower. Conversely, the 2013 note may be signed by an authorized official who did not hold such office on the date of execution of this loan agreement. The 2013 note shall be delivered to the bank or its attorney or legal representative. Section 8.6, form. The 2013 note shall be prepared and executed in substantially the form attached as Appendix A. The assignment shall be prepared and executed in substantially the form attached as Appendix B. Article 9, events of default and remedies. Section 9.1, events of default. Any one or more of the following events is an event of default under this loan agreement. If the borrower shall fail to pay any 2013 loan repayment or other sum payable hereunder when due, provided that if such failure to pay is beyond the borrower's control and directly attributable to OST, or if force majeure prevents payment when due, the non-payment shall not constitute an event of default hereunder if corrective action is promptly instituted by borrower upon learning of the non-payment, or in the event of force majeure in whatever period corrective action is practicable and diligently pursued to correction. Or B, if the borrower shall fail to observe and perform any other covenant, condition, or agreement on its part under this loan agreement for a period of 30 days after written notice, specifying such default and requesting that it be remedied, is given to the borrower by the bank, provided that if any such term, covenant, or agreement is such that non-performance or non-observance thereof cannot be corrected within such 30-day period, or if force majeure prevents correction within such period, the non-performance or non-observance shall not constitute an event of default hereunder if corrective action is instituted by borrower within such period, or in the event of force majeure in whatever period corrective action is practicable and diligently pursued to correction. Or C, if any representation or warning made by the borrower in this loan agreement shall prove to have been incorrect in any material respect when made, or D, the occurrence and continuance of any event of default as defined in the 2013 note or the collateral documents, or E, if any provision of this loan agreement shall at any time, for any reason, cease to be valid and binding on the borrower, or shall be declared to be null and void, or the validity or enforceability thereof shall be contested without lawful basis by the borrower or any governmental agency or authority, or the borrower shall deny without lawful basis that it has any or further liability or obligation under this loan agreement. Or F, if the borrower shall apply for or consent to the appointment of a receiver, trustee, liquidator, or custodian, or the like of itself or of its property, or admit in writing its inability to pay its debts generally as they become due, or make a general assignment for the benefit of creditors, or be adjudicated a bankrupt or insolvent, or commence voluntary case under the federal bankruptcy laws of the United States of America, or file a voluntary petition or answer seeking reorganization and arrangement with creditors, or an order for relief, or seeking to take advantage of any insolvency laws, or file an answer admitting the material allegations of a petition filed against it in any bankruptcy, reorganization, or insolvency proceedings. Or there shall be instituted in any court of competent jurisdiction under any law relating to bankruptcy, insolvency, reorganization, or relief of debtors, seeking in respect of the borrower an order for relief on adjudication of bankruptcy, reorganization, dissolution, winding up, liquidation, or composition or arrangement with creditors, a readjustment of debts, the appointment of a trustee, receiver, liquidator, or custodian, or the like of the borrower, or of any substantial part of its assets, or other like relief in respect thereof under any bankruptcy or insolvency law, and in such respect thereof under any bankruptcy or insolvency law, and if such proceeding is being contested in good faith, the same shall, 1, result in the entry of an order for relief or any such adjudication or appointment, or 2, continue undismissed or pending and unstayed for any period of 60 consecutive days. Section 9.2 Banks Remedies. In the event of at the time of an event of default under Section 9.1 hereof, the bank may A. Declare in a writing delivered to borrower that all 2013 loan repayments payable under Section 5.1A hereof for the remainder of the 2013 loan term and all accrued and unpaid interest and other sums due under the 2013 note being an amount equal to that necessary to pay the full interest of and principal on the 2013 note and to pay all other indebtedness thereunder and hereunder to be immediately due and payable, whereupon the same shall become immediately due and payable by the borrower, and such interest shall accrue thereon to the date of payment. In addition, the bank, with or without declaring all such 2013 loan repayments immediately due and payable, may take whatever action at law and equity may appear necessary or appropriate to collect the 2013 loan repayments then due and thereafter to become due, or to enforce performance and observation of any obligation, agreement, or covenant of the borrower under this loan agreement in accordance with Section 11.7 below. In accordance with the provisions of Section 11.7 below, upon the occurrence and continuation of an event of default, the bank may also 1. Proceed to protect and enforce its rights by suit or proceeding consistent with Section 11.7 below, whether for specific performance of any covenant herein contained, or in the aid of the execution of any power herein granted, or for the enforcement of any other right, as the bank, being advised by counsel, shall deem most effectual for such purpose. Or 2. Exercise or direct the exercise of any rights or remedies available to it under the 2013 note or the collateral documents. Section 9.3 Disposition of Funds. Any amounts collected pursuant to action taken under Section 9.2 hereof shall be applied in accordance with the provisions of this loan agreement and the 2013 note. Section 9.4 Manner of Exercise. No remedy herein conferred upon or reserved to the bank is intended to be exclusive of any other available remedy or remedies, but each and every such remedy shall be cumulative and shall be in addition to every other remedy given under this loan agreement or now or hereafter existing at law or in equity or by statute. No delay or omission to exercise any right or power accruing upon any default shall impair any such right or power, or shall be construed to be a waiver thereof, but any such right and power may be exercised from time to time and as often as may be deemed expedient. In order to entitle the bank to exercise any remedy reserved to it in this Article 9, it shall not be necessary to give any notice other than such notice as may be herein expressly required. Section 9.5 Attorney's Fees and Expenses. If an event of default as defined in Section 9.1 above occurs, and the bank should employ attorneys or incur other expenses for the collection of the 2013 loan or the enforcement of performance of any obligation or agreement on the part of the borrower will, on written and itemized demand, pay to the bank the reasonable fee of such attorneys and such other reasonable expenses so incurred, together with interest thereon from and after the date of such demand for payment at the applicable rate. Section 9.6 Effective Waiver. In the event any agreement contained in this loan agreement should be breached by either party and thereafter waived by the other party, such waiver shall be limited to the particular breach so waived and shall not be deemed to waive any other breach hereunder. Section 9.7 Waiver of stay or extension laws. The borrower covenants that it will not at any time insist upon or plead or in any manner whatsoever claim or take benefit or advantage of any stay or extension law wherever enacted now or at any time hereafter in force, which may affect the covenants of the performance of this loan agreement, and hereby expressly waives all benefit or advantage of any such law and covenants that it will not hinder, delay, or impede the proper execution of any power herein granted to the bank, but will suffer and permit the proper execution of every such power as though no such law had been enacted. Section 9.8 Remedies. In accordance with the provisions of Section 11.7 below, the bank, so long as it owns the 2013 note, or the owners of not less than 25% of the principal amount of the 2013 note issued and secured under the provisions of this loan agreement, shall have the right, either at law or in equity through suit, action, or other proceeding, to protect and enforce the rights of all owners of the 2013 note and to compel the performance of any and all the covenants required herein to be performed by the borrower and its officers and agents and employees. The owners of a majority in principal amount of the 2013 note shall have the right to direct the time, method, and place of conducting any such proceeding for any remedy available to the holders of the exercise of any power conferred on them and the right to waive a default in the performance of any such covenants and its consequences, except a default in payment of principal of or interest on the 2013 note. However, nothing herein shall impair the absolute and conditional right of the holders of the 2013 note to receive payment of the principal of and interest on such 2013 note, and such principal and interest respectively becomes payable, and to institute proceedings for any such payment pursuant to section 11.7. Article 10 reserved. Article 11 miscellaneous. Section 11.1 notices. All notices or other communications hereunder shall be sufficiently sent or given and shall be deemed sent or given when delivered or mailed by certified mail, postage prepaid to the parties in the following bank: First Interstate Bank, 402 North Center Avenue, P.O. Box 903, Hardin, Montana 59034. Attention Commercial Loan Department. Borrower: Crow Tribe of Indians, Box 129, Crow Agency, Montana 59022-0129. Attention Chairman, Executive Branch. Any of the above parties may, by notice in writing given to the others, designate any further or different addresses to which subsequent notices or other communications shall be sent. Section 11.2 binding effect. This loan agreement shall inure to the benefit of and shall be binding upon the bank, the borrower, and the respective successors in the signs. Section 11.3 severability. If any provision of this loan agreement shall be determined to be unenforceable at any time, it shall not affect any other provision of this loan agreement or the enforceability of that provision at any other time. Section 11.4 amendments waiver. This loan agreement may not be effectively amended without the written consent of the bank and the borrower. Any waiver or failure to enforce the terms of this loan agreement by a party hereto shall not constitute a waiver by said party of the right to enforce or compel performance with respect to any continuing or subsequent default hereunder. Section 11.5 time of essence applicable law. Time shall be of the essence of this loan agreement. By agreement of the parties, this loan agreement shall be governed by and construed in accordance with the laws of the state of Montana, provided that this is not intended and shall not be interpreted as a concession by the borrower that the state of Montana has lawful authority to regulate any activities of the borrower or its officers, employees, or agents. Section 11.7 captions and references to sections. The captions of this loan agreement are for convenience only, do not define or limit the scope or intent of any provisions or articles or sections of this loan agreement. References to articles and sections are to the articles and sections of this loan agreement unless the context otherwise required. Section 11.7 limited waiver of immunity. In the event any action or proceeding is commenced by the bank or the borrower with respect to enforcement of this loan agreement, the 2013 loan or the collateral documents, such action or proceeding shall be settled by binding arbitration administered by the American Arbitration Association, AAA, under its commercial arbitration rules, and judgment upon and the award rendered by the arbitrators may be entered in a court with competent jurisdiction in the matter as set forth in Appendix C hereto. Subject to the limitations set forth in Appendix C hereto, the borrower hereby specifically waives any claim or right of the borrower as an entity to sovereign immunity with respect to any such action or proceeding, and consents to the jurisdiction of the courts as provided in Appendix C solely for the enforcement of this loan agreement, the 2013 note, and the collateral documents. The foregoing jurisdictional waiver and consent provisions and the choice of law provisions of Section 11.5 above are for the benefit of the bank or other owners or holders of the 2013 note exclusively, and are not intended and shall not be construed to benefit or otherwise bestow rights on any party other than the bank or other owners or holders of the 2013 note. Section 11.8 no liability of individual officers, directors, or trustees. No recourse under or upon any obligation, covenant, or agreement contained in this loan agreement shall be had against any director, officer, or employee as such, past, present, or future of the bank, either directly or through the bank, or against any officer, member of the governing body, or employee of the borrower, past, present, or future, as an individual, so long as such individual was acting in good faith. Any and all personal liability of every nature, whether at common law and equity or by statute or by constitution or otherwise, of any such director, officer, or member of the governing body or employee of the bank or the borrower acting in good faith is hereby expressly waived and released by the borrower and by the bank as a condition of and in consideration for the adoption of this loan agreement and the making of the 2013 loan. Section 11.9, payments due on business day. If the date for making any payment or the last date for payment of any act or the exercise of any right as provided in this loan agreement or the 2013 note shall not be a business day, such payments may be made or act performed or right exercised on the next succeeding business day with the same force and effect as if done on the nominal date provided in this loan agreement or the 2013 note. Section 11.10, right of others to perform borrower's covenants. In the event the borrower shall fail to make any payment or perform any act required to be performed hereunder, then and in each such case the bank or the owners or holders of the 2013 note may but shall not be obligated to remedy such default for the account of the borrower and make advances for that purpose. No such performance or advance shall operate to release the borrower from any such default, and any sum so advanced by the bank or the owners or holders of the 2013 note shall be paid immediately to the party making such advance and shall bear interest at the applicable rate from the date of the advance until repaid. Section 11.11, authentication of documents. The officers of the borrower are hereby authorized and directed to furnish to the bank and to counsel certified copies of all proceedings relating to the issuance of the 2013 note and such other certifications and affidavits as may be required to show the right, power, and authority of the borrower to execute and deliver the 2013 note, and all statements contained in and shown by such instruments, including any heretofore furnished, shall constitute representation of the borrower as to the truth and statements purported to be shown thereby. The witness whereof the borrower and the bank have executed this loan agreement effective as of the day and the year first written above. Crow Tribe of Indians, a federally recognized Indian tribe. Darrell Coyote Chairman, Executive Branch, First Interstate Bank, a Montana corporation by its. Appendix A is the form of a 2013 note, which I'll be reading in a moment. Appendix B is the form of assignment, which is the fourth supplemental pledge and assignment agreement, which we'll be reading in a moment. Appendix C is the dispute resolution and limited waiver of sovereign immunity. 1.1, arbitration. A, any controversy or claim arising under this loan agreement, the 2013 note of the collateral document shall be settled by binding arbitration in accordance with the commercial arbitration rules of the American Arbitration Association, AAA, except as otherwise modified herein, and judgment upon the award rendered by the arbitrators may be entered in a court having jurisdiction thereof as further provided in this Appendix C. B, the arbitration shall be conducted in Billings, Montana. The arbitrator shall have authority to order specific performance and award appropriate injunctive, declaratory, or compensatory monetary relief, including interlocutory orders to mitigate damage or prevent irreparable injury to a party, but shall not have authority to award punitive damages or other non-compensatory damages. The federal rules of evidence shall govern evidentiary matters in any arbitration brought hereunder. C, the arbitrator's fees and all other costs shall be initially borne by the parties, but ultimate responsibility for payment of such costs shall be borne by the party against whom the award is rendered, except as the arbitrators may otherwise provide in a written decision. D, the award of the arbitrator shall be conclusive and binding on the parties with respect to the matters decided and shall be complied with by the parties. A party may enter an award and institute judicial proceedings to enforce the award in accordance with Section 1.2 of this Appendix C. In such judicial proceedings, neither party, without the consent of the other party, shall be entitled to contend that the award should be vacated, modified, or corrected. 1.2, judicial proceedings. A party may commence court proceedings, judicial proceedings, only to compel the other party to participate in arbitration proceedings or to enforce an arbitration award. All judicial proceedings conducted pursuant to this Appendix C shall be initially commenced in the Crow Tribal Court. Any judicial proceedings conducted in the tribal court shall be conducted in accordance with the substantive law of the Federal Arbitration Act and the procedural law of the Crow Tribal Court to the extent that such procedural law is not inconsistent with the Federal Arbitration Act and the procedures expressly provided therein. In the event that the Crow Tribal Court refuses to compel a party to participate in arbitration proceedings or to enforce an arbitration award as written, or fails to perform said functions within 60 days after commencement of judicial proceedings, or such further time as the parties may mutually agree, either party may transfer, remove the judicial proceedings from the Crow Tribal Court to the United States District Court for the District of Montana, or if it lacks jurisdiction, to the Montana 22nd Judicial District Court for Bighorn County, Montana. C, removal of judicial proceedings from the Crow Tribal Court may be accomplished by filing a notice of removal in the Crow Tribal Court and filing an appropriate application in the appropriate federal or state court, the quote deciding forum, unquote, in accordance with the procedural rules of that forum. The notice of removal and application need be executed on behalf of only the removing party, and such removal should not be opposed or contested by the other party. Upon removal, all proceedings in Crow Tribal Court shall be stayed pending final resolution of the deciding forum, and all tribal remedies shall be deemed exhausted. Upon final resolution of this matter, the order or judgment of the deciding forum may be entered in Crow Tribal Court. D, the parties waive any rights to pursue judicial proceedings related to this loan agreement, 2013 note, and the collateral documents in any court except as provided in this Appendix C. 1.3, limited waiver of borrower's sovereign immunity. The Crow Tribe, as borrower, unequivocally and irrevocably grants a limited waiver of its sovereign immunity from suit for the limited purpose of enforcing the borrower's obligations under this loan agreement, the 2013 note, or the collateral documents by means of arbitration proceedings, judicial proceedings instituted for the purpose of compelling participation in arbitration proceedings, and judicial proceedings for the enforcement of arbitration awards, all in accordance with the provisions of this Appendix C. Provided, however, that A, this limited waiver shall only extend to the bank, its successors and assigns, which includes other owners or holders of the 2013 note, and no other or third parties. B, this limited waiver shall not apply to proceedings in any court except the judicial proceedings as provided in Section 1.2 of this Appendix C. C, this waiver shall extend only for a period of time until all the borrower's obligations are satisfied under this loan agreement, the 2013 note, or the collateral documents. And D, the monetary relief available against the Crow Tribe pursuant to this waiver shall be limited to amounts that are expressly due and payable pursuant to this loan agreement, the 2013 note, or the collateral documents, including the costs of arbitration if so awarded against the borrower pursuant to this Appendix C, and shall not include any other indirect, consequential, tort, punitive, or non-compensatory damages, and in no event shall any judgment or other relief awarded pursuant to this limited waiver result in the encumbrance of any tribal property or assets which are held in trust for the Crow Tribe by the United States of America, except those trust assets specifically pledged or assigned pursuant to this agreement. Appendix D, pending litigation. Bird et al., the Crow Executive Branch Officers et al., civil case number 10-033 in the Crow Tribal Court in and for the Crow Indian Reservation. And just a note on that last matter, that has been pending on a motion to dismiss and a renewed motion to dismiss for about 2 or 3 years, but it was in there before and it's actually still there, so we just left it.
Okay, thank you. Right now, I need a motion on the floor to adopt this loan agreement. Okay, motion by Senator Stewart. Need a second by Senator Coyote Runs. Okay, need a question. Question by Senator Not Afraid. All those in favor, raise your right hand. 4, 5, 6, 7, 8. Consider it out. 8. 8 yes, unanimous, 0, 0. Okay, if you want somebody who made the J to read in the next one, which would be the, would that be the 4th supplemental pledge and assignment agreement?
Probably the note.
The promissory note?
Yes.
Okay, the promissory note. Jay will read the promissory note, and I'll hand the floor over to Jay.
Thank you, Mr. Chair and members of the Revenue Committee, Mr. Chairman, Vice Chairman. This is Appendix A to the loan agreement, titled the Promissory Note. Here we go. For value received, the undersigned, the Crow Tribe of Indians, a duly organized and federally recognized Indian tribe, together with any successors to its functions, and hereinafter referred to as the Maker, does hereby promise to pay to the order of First Interstate Bank, a Montana banking corporation, together with any successors or permitted assigns hereunder, referred to as the bank, at its offices at 402 North Center Avenue, P.O. Box 903, Hardin, Montana 59034, attention Commercial Loan Department, or at such other place, either within or without the state of Montana, as the bank or the holder hereof may, from time to time, designate in writing, in legal tender of the United States of America, the principal sum of $10 million or so much thereof as has been advanced under the terms of this promissory note, the quote-unquote note, or the loan agreement defined below, in installments as set forth below, which sum shall be payable together with interest thereon at a variable rate, subject to an annual adjustment on each January 25 during the term of this note, equal to the prime rate on the date of calculation plus 1.5% per annum. The interest rate calculated in accordance with the foregoing sentence is referred to as the quote-unquote applicable rate. As used in this note and in the loan agreement, the term prime rate means the prime rate as published in the money rate section of the Wall Street Journal Western Edition. On the date hereof, the applicable rate is 4.75% derived from the prime rate, 3.25% plus 1.5%. 1. All capitalized terms used but not otherwise defined herein shall have the meanings assigned thereto in that certain loan agreement dated as of blank 2013, the quote-unquote loan agreement, given by maker to the bank unless the context clearly requires otherwise. The term assignment shall mean and refer to that certain fourth supplemental pledge and assignment agreement dated as of blank 2013, executed and delivered by maker as assignor for the benefit of the bank as assignee with respect to the assigned interest income payments as more particularly described therein. 2. The outstanding balance of principal together with interest thereon and all other sums due here under or under the loan agreement shall be payable as follows. A. The outstanding principal balance of the 2013 loan shall be paid in consecutive semi-annual installments of principal and interest at the applicable rate on January 25 and July 25 of each year, commencing on January 25, 2014 and continuing through January 25, 2028. And 2. A final payment of all outstanding interest, principal, and other sums due under this 2013 note or under the loan agreement shall be made on or before July 25, 2028. All of the foregoing being subject to the rights of prepayment set forth below. B. All payments of principal and interest shall be applied first to interest due on the note and then to reduce the principal amount thereof. If any installment of principal or interest is not paid when due, each and every such delinquent installment shall bear interest to the extent permitted by law at the applicable rate from the due date of such installment until payment thereof. Maker shall pay all loan repayments in lawful money of the United States of America to the bank. Interest shall accrue from the date an advance is made. C. The maker may prepay and redeem this note without penalty or premium in whole or in part at the option of the maker on any one or more dates. In the event of any partial prepayment, the amount thereof shall be applied first to interest due on the note and then to reduce the principal amount thereof. All prepayments shall be applied on the principal in the inverse order of maturity and shall not relieve maker from paying the next succeeding installment or installments of principal and interest due hereunder. D. This note contemplates a single advance not to exceed the aggregate principal amount of $10 million in accordance with Section 4.1 of the loan agreement. This note does not represent a revolving credit of any nature or form whatsoever. The maker expressly recognizes that payment of the amounts due hereunder shall not obligate the bank to advance nor entitle the maker to borrow or receive any additional monies or sums under the terms of this note. E. At least 30 days before the due date of a semi-annual principal and interest payment under Section 5.1A1 of the loan agreement or the due date of the final payment under Section 5.1A2 of the loan agreement, the bank shall deliver to the maker a written statement specifying the amount of such semi-annual payment or final payment as the case may be, notwithstanding the foregoing. The failure of the bank to deliver said written statements shall in no way or manner 1. Relieve maker of its obligations to make such payment. 2. relieve, or excuse maker from the performance of its duties, obligations, or covenants under this 2013 loan, the loan agreement, or the collateral documents. Or 3, impair or diminish the bank's rights and privileges under this 2013 note, the loan agreement, and the collateral documents, but the due date of a semi-annual payment or the final payment, as the case may be, shall be extended to the date which is 30 days after delivery to the maker of the said written agreement. 3. Any one or more of the following events is an event of default under this note. A. If maker, which term for the purposes of this paragraph 3 includes all makers, sureties, endorsers, and guarantors of this note, or any extension, renewal, and or modification thereof, shall fail to make any payment of principal or interest when due, provided that if such failure to pay is beyond the maker's control and directly attributable to OST, or if force majeure prevents payment when due, the non-payment shall not constitute an event of default hereunder if corrective action is promptly instituted by maker upon learning of the non-payment, or in the event of a force majeure in whatever period corrective action is practicable and diligently pursued to correction. Or B. If maker shall fail to pay when due any other amounts due hereunder or under the loan agreement or the assignment other than payments of principal and interest due under this note. Or C. If maker shall fail to observe and perform any other covenant, condition, or agreement on its part hereunder or under the loan agreement or the assignment, and such default continues for 30 days after written notice, specifying such default and requesting that it be remedied, is given to the maker by the bank, provided that if any term, covenant, or agreement is such that non-performance or non-observance thereof cannot be corrected within such 30-day period, or if force majeure prevents correction within such period, the non-performance or non-observance shall not constitute a default hereunder if corrective action is instituted by maker within such period, or in the event of a force majeure in whatever period corrective action is practicable and diligently pursued to correction. Or D. If maker shall 1. Admit in writing its inability to pay its debts generally as they become due, or 2. Admit in writing the fact that its debts exceed a fair valuation of its property, or 3. Commence a voluntary proceeding under any applicable federal or state bankruptcy, insolvency, or other similar law, or 4. Make an assignment for the benefit of its creditors, or 5. Consent to the entry of an order for relief in an involuntary proceeding under any applicable federal or state bankruptcy, insolvency, or other similar law, or 6. Have entered against it by a court of competent jurisdiction a decree or order granting relief in any involuntary case under any applicable federal or state bankruptcy law, or appointing, with or without the consent of the maker, a receiver, liquidator, assignee, custodian, trustee, sequestrator, or similar official of the maker, or for any substantial part of its property, or approving a plan for reorganization of the maker, or ordering, or ordering the winding up or liquidation of its affairs, and such decree or order shall not be vacated, set aside, or stayed for a period of 60 consecutive days. Or E. If any representation or warranty made by the maker herein or in the loan agreement or the assignment or in any collateral documents shall prove at any time to be incorrect or misleading in any material respect as of the date made. Or F. If any provision of this note, the loan agreement, or the assignment shall at any time for any reason cease to be valid and binding on the maker, or shall be declared to be null and void, or the validity or enforceability thereof shall be contested without lawful basis by the maker or any governmental agency or authority, or the maker shall deny without lawful basis that it has any or further liability or obligation under the loan agreement or the assignment. Whenever any event of default shall have happened and be continuing, the bank or the holder hereof may declare in a writing delivered to the maker that all unpaid loan repayments and all accrued and unpaid interest and other sums payable hereunder being an amount equal to that necessary to pay in full the principal remaining due on this note, together with interest thereon, and to pay all other indebtedness or sums due hereunder or under the loan agreement or assignment to be immediately due and payable, whereupon the same shall become immediately due and payable by the maker, and interest shall accrue thereon to the date of payment. In addition, the bank or the holder hereof, with or without declaring all such payments immediately due and payable, may take whatever action at law or in equity which may appear necessary or appropriate to collect the payments then due and thereafter to become due, or to enforce performance and observance of any obligation, agreement, or covenant of the maker under this note, the loan agreement, or the assignment in accordance with paragraph 7 below. Notwithstanding anything to the contrary stated herein, the bank shall not be required to give notice to any other makers, sureties, endorsers, or guarantors of this note if, by virtue of a separate agreement or guarantee of this note, such notice is waived, or in the failure of the bank to give such notice is not a defense to the obligation under the separate agreement or guarantee. 4. Notwithstanding anything to the contrary contained herein or in the assignment securing this note or in the loan agreement, all agreements between the maker and bank are hereby expressly limited so that in no contingency or event whatsoever, whether by reason of advancement of the loan proceeds, acceleration of the maturity of the loan, or otherwise, shall the amount paid or agreed to be paid to bank for the use, forbearance, or detention of the money to be loaned hereunder exceed the maximum rates which bank is permitted to charge under applicable law. If, from any circumstances whatsoever, the fulfillment of any provision hereof, or of the loan agreement or the assignment, or any other loan document at any time, performance of such provision shall be due, shall involve transcending the limits of interest prescribed by law, then ipso facto the obligation to be fulfilled by maker shall be reduced to the limit of such validity. If either the maker or bank is exempt from applicable usury statutes, or for any other reason not limited by law, none of the provisions of the above paragraph shall be construed so as to limit or reduce the interest or other consideration of the loan payable hereunder. 5. In the event that the bank brings a suit or proceeding hereon, or an attorney be employed, or expenses be incurred in connection with a demand for payment of this note, or any portion of the indebtedness evidenced hereby or as otherwise provided in the loan agreement, the prevailing party shall be entitled to payment from the other party of all reasonable expenses and attorney's fees incurred by the prevailing party. 6. Except as otherwise provided herein or in the loan agreement, the maker, endorsers, guarantors, and sureties of this note, and each of them, hereby waive diligence, demand for payment, notice of non-payment, protest and notice of protest, and specifically consent to and waive notice of any renewals or extensions of this note, whether made to or in favor of the maker or any other person or persons. 7. By agreement of the parties, this note shall be governed by and construed in accordance with the laws of the state of Montana, provided that this is not intended and shall not be interpreted as a concession by the maker that the state of Montana has lawful authority to regulate any activities of the maker or its officers, employees, or its agents. In the event any action or proceeding is commenced by the bank or the maker with respect to enforcement of the loan agreement, this note or the collateral documents, such action or proceeding shall be settled by binding arbitration administered by the American Arbitration Association, AAA, under its commercial arbitration rules, and judgment upon the award rendered by the arbitrators may be entered in a court with jurisdiction of the matter as set forth in Appendix C to the loan agreement. Subject to the limitations in Appendix C to the loan agreement, the maker hereby specifically waives any claim or right of the maker as an entity to sovereign immunity with respect to any such action or proceeding, and consents to the jurisdiction of the courts as provided in Appendix C to the loan agreement. The foregoing jurisdictional waiver and consent provisions and the choice of law provisions above are for the benefit of the bank, or either owner or holder of the note, or other owner or holder of the note, exclusively, and are not intended and shall not be construed to benefit or otherwise bestow rights on any party other than the bank or other owners or holders of the note. 8. The terms of this note apply to inure to the benefit of and bind all parties hereto, including, without limitation, all makers, endorsers, guarantors, and sureties hereof, their heirs, legatees, devisees, personal representatives, successors, and assigns. 9. Under an assignment executed by maker and bank, the assigned interest income payments to be received by the maker pursuant to the act are intended to be applied in payment of the loan repayments, provided that the foregoing is not intended to restrict the source or method of such loan repayments by maker to sums received with respect to such assigned interest income payments, and the obligations under this note, the loan agreement, and the collateral documents shall be general obligations of maker. The terms, covenants, conditions, provisions, stipulations, and agreements of the assignment are hereby incorporated herein to the same extent and with the same effect as if they were fully set forth herein. The undersigned does hereby covenant and promise well and truly to abide by and comply with each and every term, covenant, provision, stipulation, promise, agreement, and conditions set forth in this note and the assignment and the loan agreement. This note shall evidence, and the loan agreement and the assignment shall assure payment of the loan repayments pursuant to the loan agreement, which shall bear interest at the applicable rate unless a greater rate is expressly provided in the loan agreement. Reference is made to the loan agreement with respect to rights of acceleration of all or part of the indebtedness evidenced by this note, in witness whereof the undersigned has executed this note as of the date first above written. Crow Tribe of Indians, a federally recognized Indian tribe, chairman of the Crow Tribe signature line. Mr. Chair, we move to Appendix B, which...
No. Okay, for the record, it was, that last vote we had was actually 9, not 8. So that's just a correction. It was 9 yes, 0 no, 0. So on this promissory note, the floor is, needed motion on the floor to adopt the promissory note. Okay, Senator Nonfray makes the motion to adopt. Is there a second? Senator Alden makes the second. Need a question? Question by Senator Stewart. All those in favor of adopting promissory note of $10 million loan for First Interstate Bank, raise your right hand. 9-0-0 passed. Okay. Okay, which one? The supplemental?
Yeah.
For supplemental? The fourth supplemental pledge and assignment agreement. You guys want to take a break? 5-minute break? Okay, yeah, 5-minute break.
Okay.
5 minutes. If you got them, smoke them.